of Lithuanian Constitutional Court participating. We'll start with the statements of both presidents, and we'll follow up with a Q&A session. We'll start with the statement of President of the Latvian Constitutional Court, Mr. Laviņš. Good afternoon, dear members of media. We held earlier this morning a ceremonial meeting of the Constitutional Court to present to the general public the results of the Constitutional Court work in 2022 and talk about our 2023 priorities. When it comes to the cases that we are going to adjudicate, I do believe that I should now present some of the facts and figures to you, and I will try to highlight specifically the cases that we are going to adjudicate this year, as that might be helpful for you in terms of asking questions that are of particular interest to you and are of a particular, and focus on cases that are of a particular interest for the general public. First of all, we reviewed 231 applications last year. During the reporting period, we have managed to adjudicate 22 cases. 18 cases have been completely adjudicated with final judgments, and in the case of 4 applications, we have found those applications inadmissible or have terminated the proceedings, and I would like to now present to you some of the conclusions of the Constitutional Court that might be pertinent to the general public in terms of knowledge about how our judgments have contributed to stronger rule of law. We have made certain findings in tax cases, environmental sustainability cases, and also so-called COVID-19 pandemic restriction cases and problems that our people experienced as a result of COVID-19 restrictions. As regards to the findings and lessons or conclusions, there are also conclusions, valuable conclusions in the case of the official language, and as an important element of the constitutional identity of Latvia. And one of the last findings is in the field of criminal law. There was a case when a property was seized, and this case was brought before us. Constitutional Court has indicated in this judgment that illicit proceeds should be confiscated, should be seized. As regards to the cases that we are going to adjudicate, review this year, let me go deeper into the merits of those cases. We'll soon review a case about the state guaranteed minimum income, the ceiling, and the adjustment periods, the state mandate to vaccinate against COVID-19, also port management framework changes will be under our scrutiny, and also access to education in official language only at private educational establishments is another case that we are going to hear. And then one case concerns the obligation to use municipal funds to demolish the monuments glorifying Soviet occupation. There's one case related to the land use rights and the cost involved, and then one case concerns regional development and environmental protection minister decision to suspend or revoke one of the decisions of the Čakava and Riga municipality regarding gambling prohibition, and also in the case of Riga, the land use decision and permitted construction. I don't know whether we'll be able to manage to adjudicate this case this year. It might stretch into the next year, but there is a case about the age of the trees in a clearing, so there are age restrictions for the regeneration of the clearing, and one of the decisions of the public bodies has been challenged, so there's an appeal that has been received. So first they have to go through the formal appeals procedure, and then the court will review the case. So that's as far as this year is concerned. Last year, apart from adjudicating different cases, we have maintained active dialogue with the general public and with other constitutional bodies, institutions. I would like to also underline that last year, Constitutional Court engaged in a very active international cooperation. Constitutional Court took part in the World Conference of Constitutional Courts, or World Congress of Constitutional Courts, in Indonesia. And at this international event, international organization or body established by the constitutional courts of the world, we were elected as the board member, and we will be coordinating the cooperation within this body next year. Hopefully it will contribute to ideas and findings that strengthen democratic countries. Together with our colleagues, will be developed here in Latvia, and we will also be able to share our experience of strengthening rule of law, democracy, and human rights, and protecting human rights and democracy with our international colleagues through this framework or in this format. So that's it as far as my comment goes, and I would like to now give the floor to our close and esteemed cooperation partner, the Lithuanian Constitutional Court, which is today represented by its president, whom we have the pleasure of having at our ceremonial meeting. Danute, please, the floor is yours.
So thank you very much, Mr. President Lavinch. It's my great pleasure and honor to be today in Latvian Constitutional Court and to be a guest delivering the speech in your solemn hearing for the opening of judicial year. And of course, first of all, I would like to congratulate the Constitutional Court of the Republic of Latvia with this nice ceremony, with this nice event, and of course, wish to all of you very successful judicial year of 2023 and smooth delivery of constitutional justice in Latvia. Second aspect, what I want to note, just to note our very long-lasting friendship between the Constitutional Court of the Republic of Latvia and Constitutional Court of the Republic of Lithuania. We have built our cooperation and mutual activities for many years, and I really hope that this cooperation will go smoothly also in the future and also in this year of 2023. So thank you very much for your award. Of course, this is very big honor to me. And of course, I really think that Latvian Constitutional Court is one of the best courts in Europe, actively fighting for the main constitutional values or for the fundamental constitutional values like democracy, rule of law, and the protection of fundamental rights. Now, of course, as being a guest here, I also would like to give some information about the activities of the Lithuanian Constitutional Court. In principle, we do not have such a nice tradition as you have to organize the solemn hearing for the opening of judicial year. But in principle, we are publishing annual report of the Constitutional Court, and annual report will be ready at the end of March. And in the annual report, we are also, in principle, giving the information about all activities of the Constitutional Court. And as regards the activities of the Constitutional Court of Lithuania, I would like to stress three main aspects. First aspect, of course, is delivery of constitutional justice, analysis of the constitutional justice cases. This is, of course, the most important activity of every constitutional court. In 2022, we delivered 16 judgments and about 200 inadmissibility decisions in the individual application cases. In principle, Lithuanian Constitutional Court is having many individual applications now because the individual application was introduced in Lithuania only in 2019. And here we have a big difference from Latvian Constitutional Court because you have very already good experience in dealing with individual applications. So, in our cases, in principle, in 2022, we were dealing with different aspects of constitutional problems, especially, and of course, and most importantly, there were cases related to the COVID-19 pandemic. So we had quite many cases concerning the restriction, for example, on providing the dental services, on providing beauty services. We had also some cases concerning the obligatory vaccination for employees in the state institutions. Also, we had cases concerning the so-called passport of possibilities and its legitimacy in Lithuania and so on. And many such questions concerning COVID-19 pandemic are still pending before the Constitutional Court, and in some cases not only individuals are coming before the court, but also courts of Lithuania are applying to the Constitutional Court and raising different issues concerning the legality and proportionality of the measures restricting fundamental rights during the COVID-19 pandemic. Of course, we had also some other cases related to the national security and individual interests, especially economic activity, about possibilities of some foreign companies to invest in Lithuania, whether such investment, like as a freedom of economic activity, is not in conflict with the state security interests and so on. So there were quite many cases. Individual cases, individual constitutional complaints are also raising very different issues, starting from like detention of the illegal migrants. And we had very important ruling from the Court of Justice of European Union concerning this issue, where it was suggested for the Lithuanian authorities not to use the detention only, but also to search for some alternative means as regards the illegal migrants in Lithuania. And one of such cases is also pending before the Constitutional Court, and I hope that this question about the legality of detention will be dealt in 2023 by the Constitutional Court. Other individual constitutional complaints are raising also different issues concerning the COVID measures, especially, for example, the possibility to move, the possibility to celebrate or to organize some parties. We have some cases pending and so on. Of course, there are many different questions raised in the individual application cases. So this is the judicial activity of the court. Second aspect what I wanted to mention about the activities of the Lithuanian Constitutional Court is international cooperation. Lithuanian Constitutional Court was the member member of the Bureau of the World Conference of Constitutional Justice until October 2022, because Lithuanian Constitutional Court in 2017 organized the World Congress of Constitutional Courts in Vilnius. And of course, in this platform, as mentioned by President Lavinč, with the cooperation with the Latvian Constitutional Court and Estonian Supreme Court, we were very active trying to eliminate Russian Constitutional Court and Belarusian Constitutional Court from all international constitutional courts forums, and we were able to reach this goal, and of course we are very satisfied with the result. And moreover, what I would like to underline that now, Latvian Constitutional Court in October 2022 was in principle elected as a bureau member in the World Conference of Constitutional Justice, and now your court, together with Moldovan Constitutional Court, will represent the European Constitutional Court's interests in the World Conference for the next 4 years. So congratulations and good wish in these activities. So international cooperation further, we have a very good relationship with the Latvian Constitutional Court, and what is also what I would like to mention, that in 2022, in June, Lithuanian Constitutional Court organized a tripartite meeting between the Latvian Constitutional Court, Lithuanian Constitutional Court, and the Supreme Court of Estonia. And in this tripartite meeting in Vilnius, we had a possibility to discuss the current constitutional challenges, including also the war in Ukraine and the consequences to the constitutional values such as democracy, protection of fundamental rights, integrity of the states, and independence of the state. So, from international cooperation, I would like also to mention, like the third aspect, what I wanted to say is that last year, Lithuania celebrated very nice events. It was like the year of the Constitution declared by our parliament, by our Seimas of the Republic of Lithuania, because last year, 2022, we celebrated 100-year anniversary of the Lithuanian Constitution of 1922 and 30 years Constitution of 1992. So for this event, we organized very big conference, international conference in Vilnius on 25th October 2022, and I am very happy and grateful that your President Lavinč was also present in this conference, delivering the main speech in one of our panels of the conference. And like one more aspect concerning the activities of the Constitutional Court is just to mention that the year of 2023 is the year of the Constitutional Court, because this year, 2023, Constitutional Court of the Republic of Lithuania is celebrating the 30 years anniversary of the activities of the Constitutional Court. And so, of course, this year we will have also a lot of events, publication of the book devoted to the 30 years anniversary of the Constitutional Court, and some other events. And of course, we cannot forget our main activities, delivering the constitutional justice in constitutional justice cases. So, Mr. President, I think I spoke enough, so maybe you can just, if you have some questions, of course, I am ready to answer. Thank you.
Paldies, cienījamie priekšsēdētāji, par
Thank you for this insight. And now all the media representatives have the possibility to ask questions. And please, I am Victoria from platform Rus.lv. My question goes to Mr. Lavinč. Could you tell in greater detail about two cases? One is education in the official language only in private institutions of education, and the second one about dismantling of monuments of the occupational period of occupation. Well, as regards these cases, the use of official language at the stage of the highest stage of education in private institutions. The court is going to deliver the judgment on the 9th of February. And in this case, the court will look at the regulation which was in force for a certain period of time but is no longer valid. After the judgment by the Constitutional Court was delivered, certain amendments were introduced. And I have to underscore the new amendments that were introduced also have been contested before the court. And this will be another case which the court will begin to examine quite soon. And you can expect that the judgment might be delivered in this case at the end of March or mid-March. So these are two cases which are pertaining to the use of official language at the highest level of education in private institutions of higher education. As regards the case related to dismantling of objects that are glorifying the occupation regime, this case will be examined this year during the second half of the year. The case has been prepared and has been now transferred for review. And by the end of the year, we will know the assessment of the Constitutional Court, whether the obligation established by a legal act making a municipality to use its own financing to dismantle such monuments was compatible with the Constitution. Any other additional questions? TV3 News. My question goes to Mr. Lovinch about COVID-19 measures related. We heard here also about the Lithuanian experience, having several cases. So what are your conclusions regarding Latvia? Have there been any applications because people have been dismissed from their jobs because they had failed to get vaccinated? And are you still reviewing such cases? And what's going to happen if you decide that human rights have been violated? And then what can be done retroactively? Well, thank you for your question. As you described it, namely that a person has been dismissed from their job and then legal proceedings at the Constitutional Court's level had taken place. I don't think we have had a case exactly like this, but we have a case in which a member of the parliament has contested this obligation to get vaccinated against COVID-19, and this case also will be heard this year. I believe this will be done during the first half of the year. So you have to be patient. You have to wait until the court will provide its assessment whether this obligation for the member of the parliament to get vaccinated complied with the Constitution. As regards those cases where persons had been dismissed, I believe that the administrative courts were predominantly dealing with those cases. But these decisions come too late, perhaps, because this is no longer relevant for those persons who have been dismissed. I understand. And yet, I have to say that the findings and the conclusions which are made into the cases, they create legal certainty, legal security for other similar situations. We cannot say that such conclusions have no influence. We understand very well that the parliament and the government and the court, the entire society of Latvia, at the onset of pandemics, we all were in very uncertain circumstances. And in a situation like that, the state really has to act swiftly. And it was done. But in order to make legal assessment, it takes time. And usually the court comes with its conclusion sometime after the fact. But nevertheless, this is important because it provides guidelines how to act in similar situations. If I may, another question. Of the cases still pending to be examined this year, which of these seems to be the most complex or challenging one? Well, actually, I mentioned all these cases because I believe that all of them will be very complicated. For example, the right to land use. It's a legal institution which has replaced the so-called forced land lease, where on a land plot in the ownership of another person, an apartment building has been built, and those persons who own apartments in the building, they lease this land. Some time ago, this institution was called forced land lease, and we had at least 2 cases at the Constitutional Court regarding the amount of this lease payment. And the Constitutional Court always has recognized that legal regulation was unconstitutional. And currently, the Ministry of Justice has prepared the draft law, and it has been examined by the Parliament, and the Parliament has adopted new regulation regarding these legal relations. But it has been now being presented as new legal institution, the right to use the land. And now we are going to have this very important task, whether 4% for using the land, which apartment owners are paying to the landowner, whether this is proportional or not. So this is one case. The next one, regarding this question, or the matter which has been important for all municipalities, how to restrict gambling. For example, Čakava municipality decided to ban gambling altogether, and this decision made by the municipality was suspended by an order of the minister. But the order by the minister can be subject to constitutional review. And this year, we will provide our assessment whether this minister's order was constitutional or not. And the same applies to the spatial planning of Riga. Another legal matter which we are going to deal with, and which has caused and will cause interest, is the question, the whole matter which was already referred to in one of the previous questions, whether it was constitutional to make municipalities dismantle those monuments to occupational regime, spending their own resources and not the state resources.
And I can also mention a case regarding the pay of the educators at the preschool level. This is a case that involves educators that are working at a preschool level. But whenever Constitutional Court is asked to analyze certain rights, we have to analyze it through the prism of constitutional law, and we will therefore have to take a look at the pay on all levels of education and see whether there are any differences in terms of pay at preschool level and other education levels, and see whether the equality before the law has been fully ensured in this case. And probably, as I already mentioned, towards the end of this year, Constitutional Court might announce its opinion regarding Cabinet of Ministers' decision on the main clearing and the age of the trees in the main clearing, allowing to cut some trees earlier than currently permitted by the standards. So based on our decision to review this case, we can see, or this rather shows that it is of high public interest and we have to address this, and that this judgment will be ready towards the end of this year, early next year. These are very complex cases that the Constitutional Court will have to review, and when those judgments will be announced, we will also make public announcements as regards to what our reasoning has been. I see we have a question from our Zoom journalist. Please, the floor is yours.
Sveicināti, laikam tā ir mana paceltā roka.
Good afternoon, Lee Gasponding from Latvian Radio. I raised a hand in Zoom. I wanted to ask a question about last year, about the judgments or case law of the last year and their implementation by the legislature. I know that the Constitutional Court does not have to monitor the implementation of its judgments by the legislature, but could you comment some of your judgments that had to be implemented or that mandated the legislature to make changes in the legislation, and how do you evaluate their response or their actions based on your judgments? Thank you for your question. Every time that we meet with other constitutional bodies or their leaders, whenever we meet with the Speaker of the Sejm, whenever we meet with the President of Latvia, whenever we meet with Prime Minister, we always try to discuss the implementation of judgments of the Constitutional Court. The Constitutional Court itself, as you rightly indicated, is not really responsible for monitoring whether its judgments are implemented by the party to whom this judgment is binding. We nevertheless follow what is happening in terms of the implementation of our judgments, and we have also conducted a study of how well the judgments of the Constitutional Court are implemented, are enforced. And our study shows, the study that we'd conducted, the study of the legal department of the Constitutional Court has found that in our country, we do not have major problems with the implementation or the enforcement of Constitutional Court judgments, and I can fully confirm that. There are some cases in which we are sort of struggling with the implementation of Constitutional Court judges, and there are only few and far between of such cases. I can mention only two from the top of my head. One judgment that also garnered huge public attention was a judgment about how and why are Constitutional Court judgments implemented with respect to same-sex partnerships. Legal safeguards available to such same-sex partnerships. The physical and legal protections. And in this judgment, by and large, has been implemented. The problem that we came across was that the labor law did not provide for similar maternity leave in case of a same-sex partnership. Constitutional Court found that this legal gap is unconstitutional, and Constitutional Court, several days after the deadline, however, legislature, several days after the deadline that the Constitutional Court gave it, introduced changes in the labor law, expanding the scope of application of this law. In other words, expanded the list of groups eligible for the maternity benefit or maternity or parental leave in general. Be it a same-sex partnership, be it a civil partnership, be it any kind of other family bond, for example, if it's a grandmother. So now this scope of application has been expanded, so that's the challenge that we're trying to address. What we are struggling with in terms of the enforcement of this judgment is how Parliament interprets and understands the judgment of the Constitutional Court, in particular with regard to Article 110 of the Constitution, which provides for every family's social, economic, and legal protection. So their interpretation is very essential here. How will the Parliament ensure same-sex partnership economic and legal protection is not a matter of concern for the Constitutional Court? Our judgment does not specify any particular legal provision that needs to be introduced in order to regulate all kinds of legal issues with respect to these partnerships. So it is at the discretion of the Parliament to decide how to ensure legal socio-economic protection or safeguards for these partnerships. Parliament is currently debating this issue. So the debate is ongoing. As regards to the other case that has raised questions about proper enforcement of the Constitutional Court judgments, is a case that involves the enforcement of sentences. If, for example, a man is being convicted for severe bodily harm, he must be in a special regime prison, in the highest security prison. If woman has committed a similar severity crime according to the regulation, woman will not be kept in the highest security prison or part of the prison where the highest security is ensured. So this was challenged or contested in the court, asking the court to establish whether there has been some gender discrimination, and courts recognized that there has been gender discrimination. So how to make sure that there is similar punishment? Well, we need to invest heavily into the existing penitentiary system or penitentiary buildings, or build new prisons in order to make sure that such discrimination is not taking place, gender discrimination, with regard to the enforcement of the sentences. And this is not the case where the government or the Parliament has not followed our judgment. Every time we meet with these constitutional bodies, they have clearly indicated that in a country governed by the rule of law, the judgments of the courts are respected and are followed. And I can confirm you that in this regard, there are no problems with the understanding, with the application of the principles of the rule of law in our country. But that is, of course, a good question. We'll keep monitoring how this is implemented or applied in other cases. Thank you. Dear media representatives, do you have any other questions? Yes, please. The floor is yours.
I would like to add some words about execution of constitutional court judgments in Lithuania. And in principle, I can fully follow the line expressed by President Lavinch, because in Lithuania, the judgments of the Constitutional Court, they are quite good executed. We have about 92% of executed judgments, but still also there are few judgments which are not executed for many years. And for example, one example can be provided. It's a Constitutional Court ruling of 2010 concerning the judges' state pension. This ruling has not been executed for already 12 years. So what was done, like on practical level, so the National Courts Administration in principle adopted some internal rules according to which the state pensions of judges are calculated. And of course, this is not normal. Why, of course, the parliament is not doing it? Because maybe it's also not very popular topic to grant like the pension to state pensions to judges. But normally, like the court's rulings are quite good executed. And 2 points I wanted to mention from the previous questions concerning the use of the official language, or in this case it would be Lithuanian language. We have also interesting 2 cases pending before the court concerning the using some specific letters and symbols which do not exist in the Lithuanian alphabet, like X, for example, or W, because our Seimas adopted a law allowing to use the special letters and special symbols when writing the names of Polish origin people in the Lithuanian official documents, let's say in passport and identity cards. And both cases now are pending before the Constitutional Court, and their conformity with the constitutional provision that in Lithuania official language is the Lithuanian language has been disputed. This is one point I wanted very much to raise, because I think this is very much related to your case concerning also on the use of the official language. And the second aspect, very shortly, about the COVID-19 cases, and you asked about this question. In principle, as I said, Lithuanian Constitutional Court in principle have been dealing with many COVID-19 cases, but in principle, we do not have a case concerning the dismissal of person, but we had a disputed provision, but this provision was disputed not by the individual, but by the group of parliamentarians concerning the obligation for vaccination or obligation to provide some certificates that you are not ill. And in this case, the Constitutional Court in principle searched for this fair equilibrium of the interest involved, and we were also analyzing the other possibilities, for example, possibility to work in distance. And even in the Constitutional Court, we had 2 people who refused categorically to be vaccinated, and then we were able to send them working on distance, online. So, and of course, in this case, we stated that the obligation to vaccinate or to provide certificates that you are not ill, having taking into account all these other possibilities as working online, and these provisions were regarded as being not in conflict with the Constitution. And here, of course, we used also argumentation mentioned by President Lavinch that in principle, from another side, is also the state's obligation to take some measures in such an unknown situation, which was totally new situation, to react and to protect the whole population, the whole society from the spread of this coronavirus, which at that time, it was quite dangerous virus. So this was like the argumentation. So thank you very much.
Paldies, vai būs vēl kādi jautājumi?
Thank you. Do we have any other questions? A question. It refers to colleagues' question about Parliament implementing or enforcing the Constitutional Court judgments going back to the same-sex partnerships. The current convocation of the Saima did not sort of inherit or continue the same-sex partnership law. How should we interpret it? We hear that Parliament is not following your judgments. Are your judgments being ignored or not, or are you giving them time to continue the work on this legislative initiative? What is happening with this draft law? Well, yes, we'd given them time to draft a new law or improve the legislative initiative that was constitutionally unacceptable. It was a draft law again, and this draft law has been changed. labor law has been changed, and this is a very narrow interpretation of what the case is all about. We had to deal with Article 110 provision, which says that we should legally and socioeconomically protect all families, which means that Parliament must make sure that our legal framework provides such safeguards and protections for the same-sex partnerships, legal and socioeconomic protections. How they do that, it's their discretion. We had the draft law. It went through three hearings, but wasn't eventually adopted. There was a draft law that addressed all of these legal sort of intricacies, all of these legal challenges, but eventually, Parliament did not adopt it. And of course, it is the Parliament, the legislature, that adopts a certain legislative initiative or not. And in this case, in the third reading, they decided not to adopt it. However, how they are going to interpret this specific provision is their responsibility. They are currently working on it, as we heard from the Minister of Justice. The work is being done to make sure that several legislative acts are being changed, amended in order to provide proper protection, legal, socio-economic protection for these families, for these partnerships. The problem was that probably it was all squeezed into the same law. I will not comment what Parliament did, but what we see is that by, including everything in one legal act, the Parliament decided not to adopt this mixed law, if you will. From the codification point of view, this is probably even better. But now they have to find another solution, and Constitutional Court did not order them to adopt one single law to regulate all partnerships. I hope I answered your question clearly enough. Thank you. Do we have any other questions? Yes, please. The floor is open.
Ja vairāk
If we have no more questions, I just would like to use this opportunity to remind you that the report on 2022 has been published on our homepage, and you can also follow us on social networks, YouTube account, and Twitter. I would like to thank all of you for participation and enjoy your weekend. Thank you.